This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
My lord, I am a job loser of 2016 selection process.
You are?
I am a job loser of 2016 of a selection process in 11-12 classes. My lord, what happened, my lord? Parallelly, my lord, I have participated in upper primary selection process. That particular selection process, I have been come under the provisional merit list, my lord, provisional panel. I was called for the interview first phase of counseling. The first phase of counseling, which was held in the possibly in the month of November 2020.
Mr. Dr. Patro, tomorrow certain matters are fixed.
Yes, I think so.
Similar matters.
My lord,
obtain instruction because you have issued a notification fixing date of counseling.
Yes.
On
11th of June. My lord, this is the situation, my lord. I was called for the counseling in the first phase of
whether it is a similar matter.
Yes.
Those matters I will have to check. All of them are slightly different. Here in the representation, the petitioner is saying that though called, I did not go.
Yes, because I was at that time I was working in the 11-12 classes. My lord, I have no
that the employment.
But you are called for the counseling.
My lord, at that time I was working. My lord, I was in hope that I shall be succeeded in the Boishaki Bhattacharya's case. But subsequently, Supreme Court in the month of April, my panel has been cancelled. I have been jobless immediately after I made a representation. I may be facilitated for another phase of counseling. As because I am in the panel, provisional panel, in the merit list, I have fulfilled all the. I have crossed all the hurdles. And after that,
why you did not appear in the counseling?
Why not? At that time, I was working in 11-12. Why not? Ongoing selection process is ongoing, and only praying I may be facilitated for the another phase of counseling. That much. Whether
since you have lost the job, that's why you are now praying for.
Why not? Even Honorable Supreme Court is saying. Honorable Supreme Court is.
But Honorable Supreme Court has said that only those candidates who can participate who are not tainted.
I am not.
How court will consider that you are tainted or untainted?
My lord, I am still working. They have sent me the
maybe, but you are tainted or untainted. How could whether your name was forwarded by the DI to the
yes. I am working. Lord, I have stated in my writ application.
Because tainted candidates cannot work till 31st of December.
Yes.
No. Only untainted candidates can work till 31st of December. He is working in the school now.
I have stated in my application.
Yes, Mr. Dr. Patro, he is not untainted. Had he been, he is not tainted. Had he been tainted, then he would not have been permitted to work till 31st of December.
No, I am not saying that he was tainted, but he was absent, and the rule is very specific that the absentee candidate will not be given a second chance. So, that apart, the manner in which we are carrying out this counseling, it is actually pursuant to the direction of the Supreme Court. The vacancies were specified, the candidates, the panel and the waiting list, everything was placed before the court. And everything is restricted to that panel and that waiting list.
But petitioner was an impaneled candidate. He was there in the panel.
But there are also many matters before the court where they are not even in the panel or the waiting list.
No, but where is the legal bar?
Bring them back.
Where is the bar? Because he was in the panel. Petitioner was in the panel. And that panel was placed before the court. And petitioner is now seeking because he has lost job in connection with the selection process which was conducted by the commission. Now, why petitioner will be debarred?
Now, it is too late to accommodate him. If I start accommodating, let me be more clear. The division bench directed me that we have more vacancies than candidates, so all candidates should be accommodated. But though we had more vacancies, when we put them into the categories, then we found that in certain categories there were excess candidates because the panel, my lord knows, is 1:1.4. So 0.4 excess is always in my hand. Now that we have not managed to give accommodation to all, the court is also coming down very heavily.
Applying the ratio of 1:1.4.
Yes.
That is against one vacancy, 1.4 candidates can participate
so
in the counseling.
140 candidates.
Yes, right. 100 vacancy, 140 candidates. If applying this ratio, petitioner comes within the zone, permit him.
That can only be permitted.
Permit him.
That can only be permitted after I have exhausted all my candidates in the petitioner's category. Because
it was your selection process, Dr. Patro, which was found fault by the division bench and the commission. So some responsibility you have to shoulder.
My lord, but I cannot.
The petitioners has lost the job for which petitioner should not be blamed because he is in the list of untainted category.
No. Why did everybody lose their job?
So therefore, instead of going into it was whose fault, since the petitioner.
But I will also not take the petitioner
But
as 100% innocent.
Why?
The Supreme Court did not. Everybody lost their jobs.
But the selection process was conducted by the commission.
Yes, it was conducted.
That selection process was found to be a faulty selection process.
As a result of certain.
So if this was yes. So therefore, permit at least those candidates who are coming within the zone of consideration, applying 1:1.4 ratio.
They missed their chance.
But because they are not.
Vacancies have been. My learned friend himself has submitted that he was called in the first phase counseling.
Yes.
Now we are conducting the seventh phase. That vacancy probably has been taken away by somebody else.
But he was an eligible candidate.
Very well, let me take instruction. Let me come back tomorrow because other matters my lord has also fixed. Let me check the facts in those records, in those matters also, and I'll come back to that.
No, this matter was filed on 30th of April 2025 and the date of counseling is 11th of June. Today we are on 9th.
No, that was notified only. And when this was filed, there was no.
And that is the last date of counseling, perhaps.
No, it's not. It's not. It cannot be.
Permit the petitioner.
No, kindly do not.
No, Dr. Patro.
I have a few thousand candidates to accommodate. Before this court, there are more than 500 candidates probably. And my lord is already refused in so many matters.
No,
The matters are pending. I'm not saying that finally it has been decided.
We will permit him. In the meantime, you exchange affidavits, let the writ petition be decided.
Let me also.
And do not, if petitioner is found to be a successful candidate, don't appoint him in the meantime till the decision is till the next decision is taken on the next day.
Since this seventh phase of counseling has already been notified, all the candidates equal to the number of the vacancies have been solved for the council. So if I give the decision on seventh phase, then one candidate will have to go on and check. That will also not be fair.
But that is not in dilution of merit. I am not saying so. Maintaining the merit position you allow him.
The fact that he was called in.
If by way of applying the merit position, if somebody goes, what can be done?
I thought my management was absent.
Yes, because there was a certain circumstances, Mr. Dr. Patro.
No,
I'm not. This court is not. This court will never direct that in dilution of merit. Permit him.
No, I'm not saying that.
So, in terms of the merit, if petitioner comes within the zone of consideration, applying 1:1.4 ratio, permit him or her.
Candidates cannot take a chance and then come back and put the responsibility.
What can be done? Who is to be blamed? Who is to be blamed for that?
No, but he was called.
The state government and your commission is to be blamed for that.
My lord, may I make one submission? But one thing is required to be understood. Blaming each other will not help. We will not take the.
So special situation requires special situation requires special consideration, Dr.
No,
Patro.
but the facts and circumstances are not suiting a special situation.
Where is the merit list?
May I complete, my lord?
Yes, just a minute. Where is the merit list?
Yes, my lord. My lord, merit list I have annexed page 21. My lord, SC female. First SC female. Then my lord, page 22. Page 22. Serial number 67.
Page 22.
Page 22.
Yes, name of the petition is there.
Yes.
Serial number?
Serial number 4 from upwards. Yes. 67. Mukti Vishwas.
67, yes. Female candidate.
Male, female. My lord, it is male, female.
Male, female.
Male, female, and also in general category. Page 23.
Where from you are getting general? Male, female, right? Male, female.
Female, my lord, page 23, female. SC female.
Page 22, yes.
Page 23, serial number 12, my lord. Serial number 12, female, SC female. SC female. Mukti Vishwas. And also, my lord, page 21 is a general candidate. Also in the general list also.
Page 23, SC female.
SC
then where is the marks position? Female TET weightage academic marks.
82.
Then
Total
point
marks 82.
PT marks. Then total marks 82.
82. 82.
Rank, what is F212? What is F212 rank?
F stands for female.
Female.
2 possibly stands for SC.
SC.
And 12? SC12 rank.
General, I am also in general category.
Male and MF means male, female. Male, female 2. That means civil caste.
Yes.
SC.
SC.
And then 67.
Yes. And also in general list. Serial number 21, also in general list. Your lordship, if your lordship consider page 24.
Yes.
I have page 24, serial number, first phase of counseling notice. 1514, general candidate.
1514.
1514. General candidate. I have called for as a general.
Male, female 1.
Male, female 1.
1. General. 1393.
1514.
1393.
Yes, yes. Then
1393.
Yes.
Your rank is 1393.
Yes. And
So under 3 categories, you are ranked 67, then F212, then male, female 1, 1393 general.
3 categories I have in the package. So therefore, I have called for the first phase of council. I have appeared as a SC candidate, but obtained better marks, and I also considered as a general candidate too.
But if you are attainted candidate, then you are not eligible.
There is no question. I have stated in my application I am working. I have stated in my application I am working in the school. Lordship passed and direct
regarding this issue of tainted, untainted, where you have made statement averments.
7 or 8.
I have stated.
7 or 8.
Because tainted candidate has no right to participate, as decided by the Honorable Supreme Court in the order judgment dated 3rd April.
Yes, yes. My lord, kindly consider page 9, page 5, paragraph 9. Page 5, paragraph 9. My lord, 1, 2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7. 9th line. Even the name of the petitioner is within the list of not specifically tainted, published by the WBCSC. Accordingly, petitioner is. I have stated in my application. When I find my lord GI not specifically tainted.
Any list has been published that not specifically tainted.
It was published in the public domain. That means in our website that I would have to check.
But because in other matters also it is being submitted that those candidates who are identified as not specifically tainted are being permitted to work till 31st of December.
Yes, that was allowed. That was the direction of this.
So there must have been a list prepared by the commission based on.
It was circulated amongst the concerned officials.
But since the petitioner is being permitted, to work till 31st of December, in that event, petitioner it can be presumed that petitioner might have been in the list of untainted candidates.
I will request the court that the court need not worry about it. If we find that the candidate is tainted, we will not. If we find that untainted, we will carry out whatever order comes from the court. Yes. But before the order comes from the court, may I just make 2 submissions?
Petitioner is seeking a writ. Yes. Yes.
Firstly, the petitioner actually lost his job on the 22nd of April 2024, when the special bench, the division bench, set aside the entire selection process. Sitting tight for such a long period of time, hoping for the best. We always advise that you be prepared for the worst, and you are hoping for the best. We called you for counseling at the appropriate time. We did not debar you. You still sat tight, even though the Supreme Court had already reached its fag end of the hearing, or maybe it was reserved.
But there is an order of stay by the Honorable Supreme Court.
Yes, there was. But if you are hoping for the best and you are letting opportunities go, and then at the end, when you do not get the best, when the worst happens, you want to come back and unsettle a position where candidates who were already, this proceeding is also as per a division bench direction, which even there were several appeals against it, which were all dismissed by the petitioners, not by the commission. We carried it out. Now,
No, but the court is not saying that without following the direction of the honorable division bench, you permit her or him to participate. But if petitioner comes within the zone of consideration in terms of merit, without diluting the merit position, if petitioner comes within the zone of consideration, why petitioner will not be, petitioner is being left out considering the plight of the petitioner, Dr. Patro.
To come, the candidate was not thinking about what might happen. He did not think about the negative side. And now to make our process topsy-turvy at such a late stage, when we are at the 7th phase of counseling, the waitlisted candidates are getting the opportunity of getting employment. They are also unemployed youths. They did not run away. They remained with throughout the entire process. They were not happily working. They went through the entire process of litigation for 10 years almost. Now at the brink of getting employment, if I allow absentee candidates, a candidate who was called in November is now wanting.
But how a court can shut the door of in front of this candidate who has lost job due to the misdeeds of the commission?
Maybe, but we did not debar the candidate from.
It is not that, Dr. Patro, that the candidate has approached this court after losing job because of the fault which is attributable to that candidate.
No, in that situation, possibly it would not be open to him.
See the position. It's special circumstances.
Let me come back, because since the petitioner was a multi-ranked candidate, against which vacancy his call was, he received the call. That I will have to check. Let me come back tomorrow with some.
No, Dr. Patro, today I will keep direction for 5.
Kindly do not. Sure. Keep it tomorrow, my lord. Because against which vacancy he was called also, then let him disclose the facts. Which vacancy was he disclosed? Why is my learned friend? He has not even annexed his intimation. His call for counselling, he has not intimated.
Yes, I have annexed.
Page
24.
No, intimation.
Where is the call for counselling? Where is that document?
Page 24, first phase of counselling.
Page 24,
No, this is the list. Where is your intimation? Showing the date and time when you are to come and participate. Against which vacancy, against which roster number you were called?
No. Court will direct that if he comes within the zone of consideration, he will allow him. Otherwise, not.
Yes. My lord, if that order is passed, I will have a few, maybe thousands of candidates to entertain. All 9, 10, 11, 12 candidates.
If necessary, you have to extend the time.
You
have to extend the time.
Vacancies. I'm already facing a contempt proceeding where the court is coming down very heavily upon the commission for not being able to accommodate all the candidates.
You will take this point before the contempt court that the regular bench is passing these orders. What can be done? On merit.
No, I'm not managed.
Yes.
What I have not managed to complete. The
regular bench is passing this order. What can be done?
I will have more candidates there. Vacancies have been given to other candidates. In this case,
no, I am not saying that in dilution of merit, you will permit him or her. But permit the petitioner if she comes within the zone of consideration.
My learned friend has come today before the court asking.
No, not today. This writ petition was filed 30th of April.
Today the matter is being heard. My learned friend has also not brought the list of vacancies. That is in our website. Then we could have identified that whether at all pure science there are still vacancies left, whether any candidate is being called. Out of 300 odd panels, at least 200 panels are exhausted. Only.
Where is your first counselling letter?
First counselling letter I do not have annexed. Page 24, that is the communication. That chart.
That is the panel.
There is the panel. There is no communication. Page 24 is the panel where your name is appearing at 1514.
First phase of counselling.
Yes. Male, female, general category 1393. Where is the communication that you are asked to participate in the counselling? Where is the statement in your writ petition?
So far communication I do not receive from my client.
But where is the statement that you have you have been asked to participate in the counseling.
Yes, that I have.
Where it is?
For example, paragraph 9, your petition submits a recruitment process upper primary is still going on and petition is completely competent by the name of the petitioner duly in provisional panel by the WBCC and petitioner has been called for first phase of counseling. I have stated in my application. First phase of counseling, I have been called. There is no dispute.
Date and time, yes, I am disputing. Without the records, I cannot agree. Even in the representation, he has not mentioned that he was called for counseling. He said, I did not go for counseling.
Now, how that is relevant? Even if petitioner was not called for counseling, but if he or she, if her merit position brings her to the zone of consideration, then why you will disallow him considering the plight of the petitioner? She has lost the job in a selection process which was conducted by the commission. At least that sympathy you should show.
Supreme Court did not say that. Supreme Court.
Whether the Supreme Court has debarred these candidates to participate in SLST 2016 upper primary.
The opening which the
Supreme Court has said that those candidates who are working in different departments of the government, they can go back.
Yes, so I'm agreeing. I'm here. That is what I'm trying to distinguish.
So here I quote, when the candidate has participated in the selection process, came within the if court proceeds on the premise that candidate comes within the zone of consideration, then why petitioner will not be permitted to participate in the counseling? In view of the specific observation made by the Supreme Court in connection with another batch of candidates who leaving their jobs in different government establishment have joined the post of assistant teachers and they are permitted to go back to their own position if they are not tainted candidates.
Yes, the candidate got the opportunity, but the candidate did not participate in the council.
At that point of time, petitioner was working.
No, you'll sit tight when the opportunity comes. You know that you were not working peacefully. You knew that your job was at stake. There was a very marginal chance of the order being reversed in the appeal.
Yes, sure. Affidavit of service filed on behalf of the petitioner.
Start on the vacancies. This much homework my learned friend has not done. Let me ascertain whether there are vacancies in this pure science Bengali medium school in general category.
Affidavit of service filed on behalf of the petitioner is taken on record.
Without a certain...
Next paragraph. Petitioner participated in two selection processes, namely first state level selection test 2016 for classes 11-12 or 19 for classes 11-12 and also first state level selection test 2016 within bracket upper primary for being appointed as assistant teacher in upper primary level of classes. Stop. Next paragraph, it needs to be recorded herein in view of the submission made on behalf of the petitioner that petitioner was selected in both the selection processes for being counseled in order to offer job of assistant teacher in classes 11 and 12 and in connection with first SLST 2016 and in upper primary level of classes in connection with first SLST 2016 for in connection with first SLST 2016 within bracket upper primary or for upper bracket for upper primary level of classes. Stop. Petitioner opted to be appointed as an assistant teacher in classes in higher secondary section of a government aided recognized school, since according to the petitioner it was a better opportunity for her to work as an assistant teacher in higher secondary section rather than working in upper primary level of classes, since that would have been beneficial in terms of payment of salaries and other service emoluments. Next paragraph. Unfortunately, the selection process, that is first SLST 2016 for classes 11 and 12 has been set aside. Unfortunately, has been set aside by the Honorable Supreme Court with a judgment dated 3rd April 2025, which 2025. Stop. Consequently, petitioner has approached this court with the present writ petition in order to permit her to participate in the counseling process, being an eligible candidate for being selected as for the post of assistant teacher in upper primary level of classes in view of petitioner's participation in first SLST 2016 SLST 2016 within bracket upper primary. Next paragraph. In support of such contention, documents list relevant parts of the panels or relevant parts of merit list are annexed to this writ petition at pages 22, 23 and 24. Stop. On perusal of these merit lists, it appears that petitioner ranked 67th under male-female category, being a reserved category candidate, comma, she ranked 12th under female category, being a reserved category candidate, and at the same time she ranked 1393 under male-female category, being a general candidate. Stop. It is submitted on behalf of the petitioner if, without diluting merit, if petitioner comes within the zone of consideration, she should be permitted to participate in the counseling, which is scheduled to be held on 11th of June 2025 in terms of the relevant notification issued by the West Bengal Central School Service Commission. Next paragraph. Dr. Patro, learned counsel representing the commission, has opposed the prayer of the petitioner in order to allow her to participate in the ensuing counseling in connection with first state level selection test 2016 upper primary within bracket upper primary, since petitioner, in spite of being permitted to participate in the previous round of counseling, did not turn up. Stop. It is also submitted at this stage if petitioner is permitted to participate in the counseling, if she comes within the zone of consideration, that would make the entire process topsy-turvy. Next paragraph. Yes.
The rule specifically debars absentee candidates from participating.
Stop. It is also submitted that a stand has been taken on behalf of the commission that absentee candidates are not to be permitted to participate in the ensuing counseling process, which is scheduled on 11th June 2025. Next paragraph.
One more.
Yes, yes.
And I also submitted that in the 7th phase of counseling, the notification, we have already declared the number of vacancies and called equal number of candidates for counseling. So to add any candidate would mean that one of the candidates called for counseling will have to be left out. Maybe on the basis of merit, but will have to be left out.
Another limb of submission made on behalf of the commission: if petitioner is permitted to participate in the selection, in the counseling, in the ensuing counseling, a candidate who has already been chosen for counseling would be ousted. Next paragraph. Having next paragraph. First, before considering the issue raised in this writ petition, this court needs to find out whether petitioner is an untainted candidate or not in connection with the selection process of first SLST 2016 for classes 11 and 12. Since in terms of the judgment of the Honorable Supreme Court dated 3rd April 2025, untainted tainted candidates have no right to offer their candidature in the future selection process. Stop. In this regard, it is submitted on behalf of the parties that petitioner has been permitted to continue as an assistant teacher till 31st of January, till 31st of December 2025, which goes to show that till date, petitioner has not been identified.
I have only submitted that
Petitioner has not been very well. Petitioner has not been identified as tainted candidates in connection with first SLST 2016 for classes 11 and 12. Next paragraph. This court needs to consider the issue in view of special facts and circumstances where petitioner has lost job since entire selection process, that is first SLST 2016 for classes 9, 10 and 11 and 12 has been declared illegal by the Honorable Supreme Court, vide judgment dated 3rd April 2025. It needs to be taken into consideration that petitioner also participated in first SLST 2016 for upper primary level of classes and where she was selected, but she did not participate in the previous round of counseling, since at the material point of time petitioner was working as an assistant teacher in higher secondary section. On being selected in the selection process, that is first state level selection test 2016 for classes 11 and 12. Stop. Subsequently, petitioner lost job in term after the said selection process has been declared illegal, which triggered the present writ petition, and a prayer is made to permit her to participate in the counseling process, which is scheduled on 11th June 2025. Stop. Next paragraph. In view of aforesaid scenario, concerned authority of the West Bengal Central School Service Commission is directed to permit the petitioner to participate in the counseling scheduled on 11th June 2025 if petitioner comes within the zone of consideration in terms of her merit position in the merit list, and if petitioner is not a tainted candidate.
This also allows us to verify her credentials.
Stop. Yes. The concerned authority of the commission at the time of counseling shall verify credentials of the petitioner. Stop. Next paragraph. List the matter under the heading motion on 14th July 2025, when the concerned authority of the commission shall file a report in the form of affidavit disclosing the result of the counseling. If petitioner is permitted to participate in the counseling process, stop. List the matter under the heading motion.
Kindly pass this order as an interim measure. We would like to contest.
Yes. So that's why I have placed the matter on.
Yes, but that is more like coming back with a compliance report. You might want to come back and contest. Let it be an affidavit in opposition or a report in the form of
report.
Come back on 14th.